This lawsuit and the sheriff's lawsuit and the marshal's lawsuit have to do with the total disregard of the budget process that is required by the Columbus City Charter. The mayor has decided that it's her job to set everybody's budget, and that's not what the charter says. The mayor doesn't have any role in this at all under the city charter, except the role that she has decided to take upon herself.
This collaboration of certain elected officials to sue the Columbus consolidated government and its citizens is a grand embarrassment for the city of Columbus. The law of municipal budgeting is clear and well settled. Every appropriate and deliberative step of the Charter of Columbus and the Georgia state law has been taken and followed. City Council is the city's legislative budget authority, and they have done a terrific job in balancing our revenues received with the needs of our various departments, elected offices, and overall city services. The citizens will win these unfortunate and ill-founded lawsuits. And with that, I will take questions.
And what we're pretty sure we're going to find out when we get a little bit more into this is that the city council has not been presented with any objective information on which to base the mayor's budget. Because what the mayor did was she took the 2013 city budget and she told them they were going to have to take that number and reduce it by 1.5% across the board.
We, and I mean the entire administrative staff, have no idea what he is talking about. I think that perhaps their clients are not giving them accurate information, or the information that they believe is not actually what happened. For instance, none of the plaintiffs in these lawsuits actually submitted a budget to the administration.
Countryman presented his own budget. Linda Pierce presented her own budget, and so did the sheriff. It's just it wasn't considered. It was just tossed over here to the side and nothing happened. When the budget hearing took place and the councilmen went to take their chairs around the council table, there was a copy of Linda Pierce's budget request sitting in each one of them's chair. She served them with it 3 times. And they didn't ever ask her a single question about any of her budget requests or anything. Never contacted her to get any more justification.
They never submitted a budget to the administration as they are required to do under 8-105. They submitted it direct to the city council, which is fine under Georgia law because the city council is the legislative budgeting authority of this municipal government, and they did, as frankly they've admitted in their oral statements and in their pleadings, reviewed what they submitted and rejected it. That is most certainly a deliberative budget process, and as Mr. Stone stated regarding his client, Ms. Pierce, for instance, he talked about delivery of a package to all 10 separate city councilors and an independent lobbying effort on behalf of an elected official, which is appropriate. Again, additional deliberative process. So our city council, the legislative budgeting body, clearly had information from them as to what they wished to have, considered it, and then of course they appropriated a budget, which is our FY 2015 budget.
Marshal, Countryman, Ms. Bishop, Ms. Pierce, Sheriff Darr, they are elected officials. They are accountable to the voters, the citizens, the taxpayers of this community, not to other elected officials. They work for the people of this city. That's who their loyalties lie with. That's who they owe the duty to. And it is our position that these other elected officials, led by Mayor Tomlinson and others, have lost sight of that very important fact. And we filed a similar suit. We have sued Mayor Tomlinson, the City of Columbus, Mr. Hughley, Ms. Hodge, Mr. Fay, and the City Council. And there's great commonality in the issues in these lawsuits. Now, some of what Mr. Stone will be suing over differs from what we have, but we all have a common thread, including what Sheriff Darr filed his lawsuit over.
Yes, sir. It was never submitted to our finance director, to the city manager, or to the mayor. You know, I want to keep the eye on the ball of what really are the allegations that could possibly be alleged here, but there's so much misstatement and misinformation. For instance, Sheriff Darr has sued the citizens of Columbus, Georgia for $818,000 less than he was actually appropriated. So all of this, he has demanded in his pleadings that we change his budget to be $818,000 less than the city council actually appropriated him for FY 2015. That's the kind of fatal flaw that you will see in all of these lawsuits, and to think that this type of extraordinary effort has been lodged for budgeting negotiations or whatever it may be is a real tragedy for this community.
The other day, the mayor was on the TV cameras, and she was blaming the sheriff for doing something terrible about filing a lawsuit and suing the taxpayers and costing them money so he could get more money in his budget. But we're trying not to do that in this case, because what we've done is we've sued the mayor individually, and we've sued all the council members individually, and the city attorney individually, and the finance director individually. And we've asked the court in our lawsuit to charge the entire cost of all this proceeding against them personally and let them pay it. They caused the problem, and so they ought to pay for it. It ought not to fall on the backs of the taxpayers. So we're trying to make sure that it doesn't.
We have a budgeting process with a budgeting kickoff. It would have been the finance director who provided them with an FY13 budget and then told them how far off we were from revenues predicted to be received. And then what we do is set a benchmark so that they know approximately how much that would be if we spread it out evenly, which is totally appropriate. And then we allow them to come back with recommendations of how they would amend their departments, or in this instance, elected offices, budget to meet those reductions.
When you don't fund an elected official adequately, you have to know that they're going to run out of money before the fiscal year is over, and you got to do something about that. Georgia requires a balanced budget for the entire fiscal year. The city charter requires a balanced budget for the entire fiscal year. Not for part of it, not for as long as you can last with it and then come back and ask us for more like an allowance. That's not what it is. If it was that way, it would be called an allowance system. It's a budget system. It's an appropriation for a complete fiscal year.
I would say that the lawyers and pleadings that I have read thus far have a grave misunderstanding of our charter and have admitted wholesale parts such as 7-401, which goes in depth and requires the mayor to set forth policies, changes, reductions, additions in great detail, and also provides, as it relates to elected offices, that the mayor will propose a recommended budget as to those departments, authorities, boards, and offices, and that's referring to the elected office. Again, now that is a proposal, and under Georgia law is just something for council's edification and consideration. It is council that's the legislative budgeting authority. So every paragraph that alleges that the mayor didn't do this, or the mayor didn't do that, or the city manager didn't do this or didn't do that, when it comes down to whether or not the budget is valid and there has been legislative deliberation, you look at what was presented to City Council.
From our perspective, this lawsuit really involves two critical things that the taxpayers and citizens of this city need to hear. First, the defendants broke the law. Plain and simple, black and white. The law sets out the process for the budgetary process. Mr. Stone described it completely accurately, and he also described the arbitrary and capricious nature and illegal nature that was actually carried out. And it doesn't matter who you are, the law is a law and you have to follow it. And it is our contention that the defendants in this lawsuit did not do that. The second thing that this lawsuit about is that The defendants, in our opinion, at best have misplaced their priorities, and at worst, they have acted maliciously against our clients.
They are profoundly in error in suggesting that elected officials get what they want and what they want. The law is quite clear. The Georgia Supreme Court has ruled maybe 24 times on the issue that elected officials do not get what they want. They get what the constitutional minimum requires. And they certainly can submit a budget, but the sole legislative authority for budgeting resides in this jurisdiction in City Council.